All right, we are live.
All right. Oh, yeah. All those having business before this honorable court draw near and they shall be heard. The Honorable Judges Davidson, Avila, and Granzy, with Chief Justice Cates presiding. God save the United States and this honorable court.
Um. This is the case of Liam Johnson appellant versus Michael Smith appellate before the United States Supreme Court. We have for petitioner Cameron Hecker. Yes. All right. Are you ready to proceed? Yes.
Madam Chief Justice, and may it please the court. My name is Cameron Hecker, and along with my co-counsel Michelle Sutton, we represent the petitioner in today's case, Liam Johnson. At this time, I request 2 minutes for rebuttal.
Randy.
I will be addressing the first issue before the court today of whether the bankruptcy court properly exercised jurisdiction over Liam Johnson's claims. Your Honors, this case is about denied opportunities. Liam Johnson has been denied the opportunity to have a relationship with his biological father. He has been denied the opportunity to have an untarnished memory of Paul Johnson. And finally, he has been denied the opportunity to have his claims heard in the proper court.
Is this a denied opportunity case or is this a case about damages?
This is a case about jurisdiction and damages, Your Honor. And there are 2 reasons why this court should reverse the 15th Circuit Court of Appeals and hold that the bankruptcy court did not have proper jurisdiction over Liam Johnson's claims. The first is that the bankruptcy court improperly assumed hypothetical statutory jurisdiction over Liam Johnson's claims. And the second is that even if the bankruptcy court had proper jurisdiction, it was mandated to abstain under section 1334C2 of the United States Bankruptcy Code. To my first point, Your Honors, hypothetical statutory jurisdiction is a legal fallacy and should be rejected by this court.
Isn't it just, if the claim isn't valid, isn't it just kind of an easy way to get to the final point?
That's the justification for hypothetical statutory jurisdiction that many circuit courts use. However, hypothetical jurisdiction, as this court held in Steel Company versus Citizens for a Better Environment in 1998, creates very difficult separation of powers issues and also muddles the boundaries of judicial power. And although Steel Company was discussed in the context of an Article 3 court, the same principles apply to statutory courts such as the bankruptcy court before us today.
Why is that so? Article 3 jurisdiction arises out of the Constitution.
It does, Your Honor. However, the principle of Article 3 jurisdiction that Steel Company relied on is that it's a court of limited jurisdiction. And courts of Article 1 that are granted statutory jurisdiction, while the limits are from a different origination, courts that are statutory in nature are still limited in their nature and in their
Excuse me, can Congress create federal jurisdiction by statute?
Yes, Your Honor, they can, and in this sense they did for section 1334B of the United States Bankruptcy Code, where they granted bankruptcy courts the power to have jurisdiction over cases that arise in, arise under, or sufficiently relate to the bankruptcy proceedings. However, hypothetical statutory jurisdiction still creates separation of powers issues and muddles the boundaries of judicial power because Article 1 courts are still courts of limited jurisdiction. And when a court utilizes hypothetical statutory jurisdiction, it oversteps its jurisdictional boundaries that Congress has granted it through statute to assume the case and decide the case on the merits. Even if this court chooses not to entirely repudiate hypothetical statutory jurisdiction in this case today, the bankruptcy court still applied it improperly in Liam Johnson's case. Hypothetical statutory jurisdiction is a doctrine that allows a court to assume jurisdiction when the jurisdictional question is complex and the claim plainly fails on the merits or is able to be dismissed on more obvious grounds. The Second Circuit, from one of the biggest proponents of hypothetical statutory jurisdiction, holds that more obvious grounds are typically, the examples we have of that are when the statute of limitations has run. For example, in Molesky versus McCracken, Montgomery, McCracken, Walker, and Rhodes from the Second Circuit in 2022, the court applied hypothetical statutory jurisdiction because the more obvious grounds on which to dismiss were that the statute of limitations had run by 2 years.
But we don't need to decide on hypothetical jurisdiction, right? We can still uphold local courts, even if we say there's no such thing as hypothetical.
No, Your Honor, hypothetical statutory jurisdiction is the question that was granted on certiorari to this court, and it was a limited question of whether there was hypothetical statutory jurisdiction applied properly to this case. And in the record, the bankruptcy court and the 15th Circuit Court of Appeals did not go through the analysis of section 1334B related to jurisdiction. Rather, as they indicate on page 8 and 15 of the records, they chose not to address the jurisdictional issue of related to jurisdiction and assume jurisdiction to be able to dismiss the case on the merits.
Excuse me, you're citing up in this Wisniewski case, right? Are you saying that sometimes hypothetical jurisdiction is okay and sometimes it isn't?
No, Your Honor. It's our position that hypothetical statutory jurisdiction should be repudiated in its entirety. However, hypothetical statutory jurisdiction and the way that the circuit courts applied it was applied incorrectly to Leon Johnson's case as well. So even if this court decides not to repudiate hypothetical statutory jurisdiction, it was still applied improperly to Leon Johnson's claims because there are not more obvious grounds on which to dismiss. As I was saying, the more obvious grounds on which to dismiss the Second Circuit relies on, the examples we have are of statute of limitations having clearly run. In Miller versus Metropolitan Life Insurance, the Second Circuit in 2020 held that the breach of contract claims brought were outside the statute of limitations by 13 years. And that was the more obvious grounds on which the court dismissed and was able to assume hypothetical statutory jurisdiction.
Can I take you back for a second? You mentioned related to and then you went away. So what is the question exactly that we need to answer, what we're looking for related to jurisdiction?
Your Honor, the question for related to a jurisdiction is whether the third party proceeding would have a conceivable effect on the bankruptcy state. However, the question on certiorari is whether hypothetical statutory jurisdiction was applied correctly. And because the bankruptcy court and the 15th Circuit Court of Appeals did not go through the analysis of section 1334B and instead held that the indemnification claim was a circuit split that it decided not to address, this court cannot of its own volition address the 1334B related to jurisdiction issue, and instead this court would have to remand to the bankruptcy court to then complete the section 1334B analysis before this court is able to hold that the bankruptcy court has proper jurisdiction over the claims here today.
So what relief are you asking from this court?
Well, Your Honor, we're asking that this case be remanded to the proper New Lincoln State Court, because even if this court did have proper jurisdiction under section 1334B or hypothetical statutory jurisdiction, it was still mandated to abstain from hearing the state claims under section 1334C2 of the Bankruptcy Code. And to that point, the section 1334C2 of the Bankruptcy Code, we see from page 9 and page 20 of the record that the only element and issue for mandatory extension here today is whether the case is capable of timely adjudication in the state court.
But is there anything in the record that really talks about the state court's ability to adjudicate the claim?
There are several factors that we look to determine the state court's ability to adjudicate a claim. And one of those factors is the state court's calendar compared to the federal court's calendar. And there's nothing in the record about whether the state court calendar or federal court calendar is capable of timely adjudicating these claims.
However, we remanded them back to bankruptcy court, have an evidentiary hearing on that?
No, Your Honor, because there are 4 factors in the timely adjudication analysis, and 3 of those factors can be discussed. And the first factor is held neutrally as there is no evidence. So we will take that as a neutral factor, and there are 3 other factors that we can look to. The other factors include the complexity of the state law issues, the status of the bankruptcy proceeding,
and whether the remand to the state court would unduly prolong the administration of the estate. However,
Wouldn't the bankruptcy court be in the best position to know whether it would unduly prolong the administration of the estate?
that's possible, Your Honor. However, the Southern District of New York bankruptcy courts have held that the first two factors, the backlog of the state court and the federal court, and the complexity of the state law issues should be analyzed first. And if neither of those factors weigh in favor of the federal court being the timelier forum for adjudication, the third and fourth factors don't even need to be discussed. So here, the first factor admittedly weighs neutrally because there is no evidence in the record as to the bankruptcy court or the state court's backlog in their respective calendars.
Is there a confirmed plan yet in chapter 11?
No, Your Honor, page 7 of the record indicates there has not been a confirmed reorganization plan in the bankruptcy proceeding. However, the second factor, the complexity of the state law issues, weighs heavily in favor of mandating abstention. In Parmalat Capital Finance Limited versus Bank of America Corporation, the case in which we get these four factors from, the court did hold that time is of the essence in the Chapter 11 bankruptcy proceeding, however, still mandated that abstention was necessary.
What is the standard of review for abstention?
The standard of review for abstention is de novo, Your Honor. In Parmalat, sorry?
I'm sorry, what does de novo mean?
De novo is with fresh eyes, so this court will review it as if the bankruptcy court and 15th Circuit Court of Appeals had not made it. In Parmalat Capital Finance, discussing the second factor, Parmalat is very similar to Liam Johnson's case here. In Parmalat, the Second Circuit held that the bankruptcy court erred in asserting jurisdiction because the issue there was whether the in pari delicto defense was able to be used under the theory of Illinois state law. However, Illinois had not had any case law or statute for guidance to be given to the bankruptcy court. So there in Parmalat, although the Second Circuit did acknowledge that the third and fourth factors may have weighed in favor of denying abstention because of the status of the bankruptcy proceeding and the burden of remanding to the state court unduly prolonging the bankruptcy estate's administration. The second factor, that the state court had deference and had a significant interest in deciding its own state law, outweighed the others and mandated that the bankruptcy court abstain from hearing the claim. Liam Johnson's claim is exceptionally similar to Parmalat in that New Lincoln has not recognized whether it would accept wrongful life claims as viable claims. There's no state case law or history for the bankruptcy court to have relied on. And as the bankruptcy court mentioned on page 10 of the record, this is a case of first impression in New Lincoln.
That means that there's no background in the state court either for it to determine whether this claim exists, right?
That's correct, Your Honor, and that's precisely the issue, is that states have a deference in deciding their own tort law. And here we have tort law claims that have been presented, and New Lincoln has a significant interest in adjudicating and determining whether it will accept Liam Johnson's claims as being viable claims and viable causes of action for recovery.
But under the Red Hawk case, doesn't the bankruptcy court have the discretion in determining whether this is a claim?
Your Honor, I'm not aware of the Red Hawk case. However, the related to jurisdiction is not a issue that this court is able to decide at this time, because the question on certiorari is whether the court properly exercised hypothetical statutory jurisdiction. So although the court did assume hypothetical jurisdiction and assume it would have related to jurisdiction under 1334B, it did not actually complete the analysis. And therefore, this court cannot now analyze 1334B on its own volition. And additionally, the factors weigh heavily in favor of mandating abstention, even if this court did have proper jurisdiction. And Your Honor, it is for these reasons that we ask you not to deny Liam Johnson his opportunity to have his day in court. And we ask you to reverse the 15th Circuit for the Court of Appeals. Thank you.
Counsel, thank you for your arguments. Your counsel, Ms. Sutton.
Yes, Your Honor.
You ready to proceed?
Yes, Your Honor.
Thank you so much.
Madam Chief Justice, and may it please the court. My name is Michelle Sutton, and as my co-counsel stated, we represent the petitioner in today's case, Liam Johnson. I will be addressing the second issue before the court today, whether a child may sue a fertility doctor for emotional harm arising out of an IVF procedure in which the doctor, without permission, substituted his own sperm for the sperm of the individual the child believed to be his father. Your Honors, this case is about denied opportunities. Liam Johnson has been denied the opportunity to present his case because the lower courts have dismissed his claims. We ask this court to reverse the decision of the 15th Circuit Court of Appeals for 3 reasons. First,
Kimberly, let me interrupt you. You talked about denied opportunities, and your co-counsel talked about denied opportunities. In my view, this is a case about economic harm that was caused to your client based on negligent infliction of emotional distress, isn't it?
yes, Your Honor, you're correct. That is the heart of our issue. However, we're using denied opportunities as a way to illustrate to the court that Liam Johnson has been denied the opportunity to present his case because a 12b6 motion was granted against him.
Well, wasn't he not an opportunity to present his arguments before the bankruptcy court?
Your Honor, he was not allowed to present any evidence or any, there has not been any discovery on his factual claims, and that is why we're arguing that he's been denied the opportunity to proceed with the claims that he has brought to the court. And that is why we're saying it was not a denied opportunity.
So what exactly is the theory of this claim?
Liam Johnson is alleging negligent infliction of emotional distress and medical malpractice based on the extensive emotional harm that he has suffered because of the actions of Dr. Michael Smith. We are asking this court to reverse the decision of the 15th Circuit Court of Appeals because first, Liam Johnson has not asserted a wrongful life claim. Second, because Dr. Smith owed Liam Johnson a duty of care. And third, because Liam's allegations fall into the narrow category of cases that allow for recovery when there is only emotional harm.
So if you conceded on the issue of wrongful life, would New Lincoln have Smith?
Your Honor, if we conceded on the fact that this was a wrongful life claim, then the case would be dismissed. However, this is not a wrongful life claim. Wrongful life is only present when the child is asserting that they should not or would not, or that they would have been better off not being born. For example, in Procomic by Procomic versus Silo in the Supreme Court of New Jersey.
Got it. So this isn't a wrongful life case. Is it a wrongful birth case? What are we dealing with?
Your Honor, this is a negligent infliction of emotional distress case and a medical malpractice action. The allegation that Liam Johnson is asserting a wrongful life claim based on the facts that he has alleged is misguided and wrongfully placed in this case.
Why?
Because a wrongful life claim is Your Honor, a wrongful life claim is only present when a child is alleging that they shouldn't have been born. In this case, Liam Johnson is not asserting that he should not have been born. He is asserting emotional harm based on the negligence of Dr. Smith.
Well, how do you like about somebody born?
I'm sorry. Go ahead, I defer to Steve.
How are you going to calculate the damages on that?
Your Honor, Liam Johnson has alleged a number of emotional harms, such as his inability to sleep, he's taking anxiety medication, he is seeking out things to treat his emotional harm, and those are damages that courts have measured in a number of different cases. Liam Johnson is not asking this court to measure any type of existence versus non-existence, which is why the courts have rejected wrongful life claims in the past. He's simply asking the court to measure his economic harm, which is something that the courts do in many different cases.
Can you give us examples of how to determine Liam's suffering without comparing life as it is to how it would have been if he had not been conceived?
We are not asking, Your Honor, we're not asking the court to determine his damages based on what his life would have been like if he had not been conceived. Mr. Johnson is asking for damages based on his emotional harm and what it would have been like had Dr. Smith never caused his emotional harm by failing to inform his parents that he was going to use his own sperm in the IVF procedure.
How did he have it? How?
Your Honor, that is something for a fact finder to do. It is, at this point in the proceedings, we're only at a 12b6 motion to dismiss. This court has to take the factual allegations of emotional harm at face value as true.
When we talk about emotional damages and calculating them, I'm concerned that we're going down maybe a slippery path here. We've got the head tap payment, you know, we talk about the zone of danger. And are we gonna worry now that the grandma and the grandpas are gonna join in down the road, or how do you limit who can make such a claim?
Your Honor, we recognize your concern in that the scope of liability may be implicated here, but under the Hedgepeth case, there are specific narrow requirements for recovery for negligent infliction of emotional distress. The Hedgepeth case did analyze the exceptions that New Lincoln has adopted, including section 47B of the restatement of torts. And under that restatement, the defendant has to have a special relationship with the plaintiff that necessarily implicates the plaintiff's emotional well-being. That does not mean that every grandma or grandpa can bring a claim, because they have to have a special relationship with the doctor.
Does that mean that there has to be foreseeability in that relationship?
Yes, Your Honor. The original piece of a negligence claim, and the one that needs to be shown to survive a motion to dismiss, is duty, which foreseeability plays into. And generally,
Aren't those different concepts?
yes, Your Honor, duty and foreseeability are different concepts. However, foreseeability creates duty in a sense, because it is a factor that is weighed in determining whether or not a doctor owed a duty to another.
Does the restatement reject foreseeability?
Your Honor, the restatement requires not only foreseeability, but an especially likely risk of emotional harm. So it does not reject foreseeability, it simply requires a higher standard of foreseeability. And when a reasonable doctor can anticipate an emotional response from his actions, that is especially likely emotional distress. In the Hedgepeth case, the patient was misdiagnosed with HIV by a doctor, and the District of Columbia Court of Appeals in that case held that that plaintiff who had sued the doctor for medical malpractice had met all of the 47B exceptions. Because the doctor
In the Hedgepeth case, wasn't the individual the patient of the doctor?
Yes, Your Honor, he was a patient of the doctor.
Here we don't have that.
That is correct. However, we do have a case where Leanne Johnson is the third party beneficiary of a doctor-patient relationship, which goes back to the duty piece that we are needing for a negligent infliction of emotional distress case.
Why wouldn't the parents be the appropriate party?
Your Honor, the parents, of course, would be an appropriate party to bring a claim in this case. Mrs. Johnson chose not to pursue a claim against Dr. Smith. But that is not to say that Leanne Johnson is not also an appropriate party to bring a claim against Dr. Smith for his negligence.
But Liam is not a patient, so are we not stretching doctrine a little bit too far when we allow a non-patient to sue for something that was only directed to another party?
No,
Right, I'm sorry. That's human conscious. Keep going.
No, Your Honor, we're not extending the scope too far. Courts have extended duty to a third party beneficiary when the doctor is aware that he is performing services for the benefit of a third party. Here, the IVF procedure was to benefit Leanne Johnson because it is the exact thing that resulted in his existence.
Because IVF was to benefit his mom and dad, not him.
That is correct, Your Honor. The IVF procedure was to benefit his parents. However, because it resulted in Leanne's existence, he is a beneficiary of that IVF procedure, which is why it extends the duty from Dr. Smith to Leanne Johnson.
When did the duty begin?
The duty begins at the moment of conception. As soon as Leanne Johnson came into existence, Dr. Smith owed him a duty. But before that, courts have also extended duties to defendants, to patients that had not been conceived.
It's just a continuous duty?
It is a duty based on the negligent. So because the actions of Dr. Smith during the procedure, and because the procedure is what created the duty, that is the, where Dr. Smith owed William Johnson a duty. When the actions, Dr. Smith owed Liam a duty because it was foreseeable, because of the actions of Dr. Smith were the direct consequence of Liam's injury, that is foreseeable to Dr. Smith. We can infer foreseeability in this case based on the fact that Dr. Smith did not disclose to the parents that he had used his own sperm in the procedure. It begs the question that if Dr. Smith didn't think there would be any harm from his actions, that he might have just already disclosed that to the parents.
What case law do you have that says courts have extended duties to patients who have not yet been conceived?
Your Honor, we looked at the case of Walker versus Rank from the Supreme Court of Indiana. In that case, a doctor was treating a pregnant patient for a blood disorder, knowing that she was going to have or wanted to have subsequent children. He negligently administered the medication to her, and it resulted in her children having birth defects. So when the children sued the doctor for medical malpractice, the court extended the duty to those children because they were third-party beneficiaries of the doctor administering medication to that mother.
But those were future children, not all at the same time.
No, Your Honor, they were the child that was conceived at the time, and also the subsequent children that came later.
But the injury was on that one case, that first child.
All three of the children were injured and had birth defects based on the doctor's negligence from treating the mother and negligently administering.
In that initial birth,
I'm sorry.
during that initial birth, because of transfusion.
It was deformities that they were born with because her blood disorder had not been properly treated by the doctor. So we analogize this case because Liam Johnson is the beneficiary of this IVF procedure. And it was directly, his injuries are directly related to the fact that Dr. Smith did not disclose the fact that he was going to be using his own sperm in the procedure.
But these aren't physical injuries, these are mental health injuries, correct?
Yes, Your Honor, they are emotional damages. However, the court does not indicate that the only reason they extended the duty was because they were physical injuries. So we can still analogize this case because emotional harm is just as serious as a physical deformity.
So before I became a Supreme Court justice, I was a law professor. I had an article called Mother's Baby, Father's Baby. Under your theory, can someone sue a person who had a secret affair with that person's mother, alleging emotional distress for being the child of a affair?
It's possible, Your Honor, that in your hypothetical that a person would be able to bring a claim in that case against the father because duties have been extended in those types of cases. However, that is not the case that we have here. Dr. Smith owed Liam Johnson a duty based on the third-party beneficiary extension. He also, Liam Johnson's claims fit into the narrow category of cases that allow for recovery for only emotional harm. Liam Johnson.
Section 47, aren't we supposed to ask whether or not this liability could be limitless?
Your Honor, the section 47B is a very narrow application of negligent infliction of emotional distress. It is precisely what creates the narrow scope of liability. So if a plaintiff fits into this category, that is limiting the scope of liability. And Liam Johnson does fit into this category, and he has, I see that my time is expired.
Okay. Thank you very much. All right. Anybody want to just respond to Ms. Whitman? Yes. Ready?
Your Honors, Madam Chief Justice, may it please the court. My name is Emma Goodman-Fish, and I, along with my co-counsel Zara Khan, represent the respondent, Dr. Michael Smith. I will first discuss the bankruptcy court's proper exercise of hypothetical related to jurisdiction, while my co-counsel will discuss how the petitioner plainly failed to speak. This case is about respecting established law and the intentions of the legislature. The petitioner is bringing forward a claim.
You say it's an established law, is this court ever about it? Hypothetical?
No, Your Honor, that does not speak to hypothetical jurisdiction, and hypothetical jurisdiction has, excuse me for misspeaking, hypothetical jurisdiction has been accepted by this court in Steel Co. versus Citizens for a Better Environment, in which the court authorized federal courts to continue using hypothetical statutory jurisdiction while excluding them from using hypothetical constitutional Article 3 jurisdiction. The petitioner in this case is bringing forward claims that, although synthetic, do not have grounds under established law. To respect the intentions of the legislature in enacting Section 1334 of U.S. Code 28, these claims would most be properly heard and adjudicated in bankruptcy court. This court should affirm the holding of the 15th Circuit Court of Appeals for the following 3 reasons. First, the bankruptcy court properly exercised hypothetical statutory jurisdiction.
I've got a problem with this hypothetical jurisdiction. It just seems like you're asking the court to legislate. Isn't that it? If I assume hypothetical jurisdiction where none is specifically set forth, then aren't I just taking the place of any vote who votes for a representative who should be? Am I saying votes don't count and legislators, we don't need them? We can handle it.
No, Your Honor, that is not how hypothetical jurisdiction would apply under hypothetical statutory jurisdiction, which only applies when 2 requirements are met that were established in Leslie versus Montgomery in the Second Circuit. First, that the jurisdictional issue is complex, and second, that the merits of the claim plainly fail. Both of these requirements must be met in order to proceed with hypothetical statutory jurisdiction.
What makes these jurisdictional issues complex? I hear that used a lot, but I want to know why.
The jurisdictional issues presented in this case are complex because it handles a issue of related to jurisdiction under Section 1334. As page 5 of the record notes, Dr. Smith has an indemnification agreement with the debtor, which creates such related to jurisdiction. This related to jurisdiction that comes from an indemnification agreement is contested between the circuit courts, as the 2nd, 5th, and 6th circuits all find that indemnification agreements give rise to related to jurisdiction, while only the 3rd Circuit disagrees.
What is the 3rd Circuit say?
The 3rd Circuit argues that when an additional lawsuit is required in order to have an impact on the bankruptcy estate, this would not give rise to related to jurisdiction. However, in Celotex Corporation versus Edwards, this court determined that a contractual claim, in that case, a bond agreement would be a contractual claim between the 3rd parties, between the debtor and the person who the 3rd party was bringing claims against, and additional litigation was necessary before there be an impact. This still did create related to jurisdiction, so can be analogized with this case and why an indemnification agreement would still give rise to related to jurisdiction.
Without a specific indemnification lawsuit, aren't all of these potential indemnification claims, which there's a maximum of 6, speculative at this point?
While the claims are only potential claims, if you are discussing, Your Honor, the additional claims that may be brought forward against Dr. Michael Smith, these additional claims would still be analyzed as a part of the related to jurisdiction understanding, because under related to jurisdiction as established in the Core versus Higgins in the 3rd Circuit, when looking at related to jurisdiction, it must be analyzed at the time the lawsuit is filed. And here there are 20 other times, as page 5 of the record explains, that Dr. Smith completed the same procedure, and 5 other potential claimants that may come forward with their claims. Therefore, these additional potential claims that come forward have an impact that can conceivably affect the bankrupt estate and should be considered in the analysis related to jurisdiction.
Has the Supreme Court ever approved of the conceivability test related to?
In Celotex Corporation versus Edwards, the Supreme Court spoke to the Core versus Higgins test, which determined the conceivability standard for related to jurisdiction. And in that case, as I mentioned, spoke about contractual agreements creating related to jurisdiction. Related to jurisdiction is a standard that can be understood to include indemnification agreements because of direct link and conceivable impact that this indemnification agreement between Dr. Smith and the debtor would have on the bankrupt estate. Turning back to my first point, we're pleading to hypothetical jurisdiction.
Why should the clinic who sought bankruptcy protection here feel on the benefit of this kind of protection when in fact there are no claims that have been filed?
Your Honor, the respondent's position is not that this is a benefit to the debtor, rather that this is the appropriate forum for such claims to be adjudicated.
I have a question on that. We've heard that this is a claim for emotional distress. Is that a personal injury claim?
A claim for emotional distress would be a tort claim as qualified in this case. And there are other circumstances in which bankruptcy courts have handled similar tort type claims in Second and Sixth Circuit. In both of those cases, these state law tort claims were adjudicated in a bankruptcy court because of an indemnification agreement that existed to create sufficient limited jurisdiction.
Because if it is a personal injury claim, and I don't know if it is or it isn't, that's why I asked the question. The bankruptcy court under 172B wouldn't have jurisdiction to hear it, so that claim would have to go back to state court.
In this case, Your Honor, the petitioner is asserting claims of medical malpractice and negligent infliction of emotional distress as stated on the record at page 2. So with the facts established in the record of the claims that the petitioner is bringing forward, the bankruptcy court does have proper jurisdiction to hear the petitioner's claims under section 1334. Turning again back to hypothetical jurisdiction and why the bankruptcy court was properly authorized to exercise hypothetical statutory jurisdiction. While opposing counsel brought up Seal versus Citizens for a Better Environment against hypothetical jurisdiction, that case only prevented courts from using hypothetical constitutional jurisdiction. Therefore, this court using hypothetical statutory jurisdiction relating to the complex statutory issues that are present in this case was a valid exercise of such hypothetical related to jurisdiction. Turning to my second point regarding related to jurisdiction. The bankruptcy court again was authorized to use related to jurisdiction under section 1334B because of the indemnification agreement that exists between the debtor and the third party claims that would come forward.
If the underlying bankruptcy case, are there assets that are going to be available against your creditors?
The interests of the creditors are at stake. While Chapter 11 does put on pause those assets at this time, it is still to be considered the necessity of the expedient administration of the bankrupt estate, which does place the court.
Talking about the unencumbered assets, those would be available for unsecured creditors. The clinic, do they have any such assets? Are we forcing this claim into a bankruptcy where there's going to be nothing for the unsecured creditors anyway? You know,
the record was not clear as to whether there were unsecured assets that the clinic does have at this time. All the record indicates that the debtor filed bankruptcy under Chapter 11. And with what we know about Chapter 11 bankruptcy, a bankruptcy court would be the most proper forum to adjudicate these claims under the understanding that they are Chapter 11 bankruptcy claims.
because bankruptcy courts deal with emotional distress claims so often.
No, Your Honor, it is because the related to jurisdiction allows for a bankruptcy court to extend their jurisdiction through such claims, as the Second and Sixth Circuit have illustrated in Henry Dowling and Henry Pharma. State tort claims, such as the ones that Liam is bringing forward, could be properly heard and adjudicated in a state court, a bankruptcy court forum, when there is such related to jurisdiction that exists.
Why should we allow a bankruptcy court that doesn't routinely handle these kinds of claims to determine such a complicated issue?
Congress enacted Section 1334B in order to expand the jurisdiction of federal bankruptcy courts for efficiency and for the proper administration of such bankrupt estates. And following Congress's intentions would be to allow this case, as the bankruptcy court did, to be heard in bankruptcy court. And the bankruptcy court could properly speak to these claims because these claims cannot be separated from the bankruptcy issues that are inherently involved with claims that the petitioner is bringing forward.
Why can't they be separated?
These issues,
I mean, we're not looking at, the debtor's estate here, we're looking at whether or not there's a valid claim under the Minimum law.
Not looking at opposite plan, we're looking at
Retention.
because the petitioner is bringing forward his claims against Dr. Michael Smith, who is indemnified by the now bankrupt estate, there is a clear link to bankruptcy that implicates the bankruptcy and cannot be separated from the petitioner's claims.
I heard you say that. Why? Why is there a clear link?
The clear link is the indemnification agreement as noted on page 5 of the record, and while there is a possibility that the petitioner could certify separately the question of the state law court claims, that has not been done at this time. Instead, these two issues are being brought together, and the responsible party for the damages would be the bankrupt estate because of the indemnification agreement.
So now we're also gonna let the bankruptcy court, determine whether or not the contract between doctor and clinic is applicable and what the extent of the indemnification is, without any litigation that's been filed.
Page 4 of the record indicates that the debtor has not admitted the obligation to indemnify Dr. Michael Smith yet, so the bankruptcy court could be equipped to handle that claim of indemnification if Dr. Michael Smith brings his claim forward.
Aren't they going, isn't the bankruptcy court going to have to do that if they're gonna decide Liam's claim?
Yes, Your Honor. The bankruptcy court would have to handle the indemnification agreement claim. However, it depends on which court the petitioner, the respondent, Dr. Michael Smith, brings these claims forward in. However, it will most likely be a bankruptcy court.
Why couldn't a state court adjudicate this case? Is there any reason to believe that a state court would, adjudicate expediently?
That brings me to my third point regarding mandatory extension. As Your Honor is bringing up the fifth factor of mandatory extension regarding whether a state court could timely adjudicate these claims that are brought forward. The state court, as opposing counsel mentioned, it has not been discussed the backlog of the state courts, and the petitioner offered no information regarding such backlog. Therefore, it is not clear how long this would take in state court and how much the backlog would place on state courts. Additionally, it would take prolonged repeated discovery and additional litigation in order to bring this case back to the state court forum and adjudicate the petitioner's claims there when they have already been determined in 3 courts through the proceedings that have already
As
taken
far as
place.
Mr. Johnson's concerned, plans just against Dr. Smith. So whether Dr. Smith is indemnification, I don't know that Liam cares. He wants to be paid by the doctor, so aren't we just delaying the process by making him wait and go through this bankruptcy proceeding?
No, Your Honor, it is more efficient to bring these claims into bankruptcy
Efficient for who?
for both the petitioner and the bankrupt estate. However, the interests of the bankrupt estate under section 1334B must be considered because of the nature of these claims and how they implicate the bankruptcy. Because the bankruptcy is implicated, the interests of the creditors and the bankrupt estate are also at play in this case, and that is why a bankruptcy court was the most proper forum to adjudicate these claims, as opposed to a state court that does not have such knowledge or expertise on bankruptcy issues. That brings me to the final points regarding mandatory extension, and that a state court could not properly and timely adjudicate the petitioner's claims, and that a bankruptcy court most properly and timely adjudicated the petitioner's claims regarding section 1334B. For the foregoing reasons, this court should affirm the holding of the 15th Circuit Court of Appeals. Thank you.
Good afternoon, Your Honors, Madam Chief Justice. My name is Zara Khan, and I also represent the respondent, Dr. Michael Smith. Today, in order to maintain a clearly established law, this court should affirm the holding of the 15th Circuit Court for the following 2 reasons. First, Liam Johnson failed to state viable claim of negligent infliction of emotional distress. And 2, Liam Johnson is instead asserting a wrongful life claim that New Lincoln failed to recognize. Turning to my first point,
How do we know that New Lincoln would fail to recognize this?
Your Honor, New Lincoln would fail to recognize wrongful life claims because they would follow the guidance of 38 other jurisdictions that also fail to recognize wrongful life claims. And even in those 3 jurisdictions that do recognize wrongful life claims as appropriate for recovery, they only allow recovery for special damages in which a child has incurred lifelong or severe medical expenses as a result of a physical birth defect or disorder. So for example, in California, there the court granted damages because a child who was asserting a wrongful life claim had experienced hereditary deafness as a result of a physician's negligence and now required lifelong medical care.
So are you just suggesting that a physician who causes the type of harm that Dr. Smith caused, to Liam is just not liable?
I apologize, could you repeat the question?
So you gave the examples just now, and in Liam's case, are you just suggesting that a doctor like Dr. Smith should not be liable in tort for the type of harm that Liam suffered?
Your Honor, the respondent's assertion today is that the particularized harm that Liam Johnson is asserting is not one that is recognized under New Lincoln law. And so that is not to say that Dr. Smith cannot be held liable for general torts. However, Liam Johnson is simply not the appropriate plaintiff to bring forth this claim, and therefore his claim plainly fails. Turning to my
Why isn't he the proper person to bring this claim?
Your Honor, Liam Johnson is not the appropriate plaintiff because Dr. Smith did not owe a duty of care to Liam Johnson.
Wasn't it foreseeable that his sperm would have some effect on Liam's life?
Your Honor, while foreseeability may be a factor that courts take into account when determining whether there is a viable claim, as this court held in Consolidated Rail Court versus Gottschall, quote, conditioning liability solely on foreseeability is hardly a condition at all. In fact, in Schack versus Schack, the Alaskan Supreme Court also held that conditioning liability or saying that foreseeability on its own would be a determinant factor in order to hold whether or not there was a viable claim would open the door for limitless liability, and plaintiffs must also prove that there was a particularized breach or duty or obligation that the defendant committed that would bring forth this type of legal action. And so while the harm to Liam Johnson may have been foreseeable, and that can certainly be a factor that this court takes into account today, that should not be the only factor or even the most important factor taken into consideration as to whether or not Liam Johnson should be allowed to recover.
But the liability here isn't limitless. And if you look to the dissent in the circuit court, the dissent clearly found that the liability wasn't limitless, correct?
Your Honor, when you say circuit court, could you clarify as to what the appellate? I apologize. The appellate court in this particular case?
Yes.
Your Honor, while it may not open the door for limitless liability, a number of courts, including the Hedgepath Court, as cited by opposing counsel, also held that foreseeability on its own cannot be the only determinative factor as to whether there is a viable claim. The plaintiff would still need to prove that there was a duty owed to the plaintiff and that the defendant breached that duty. And given that, as noted on page 23 of the record in Grant versus Davis, New Lincoln adopted the general no liability rule for purely emotional distress claims that are not accompanied by a showing of physical injury. Expanding that scope of liability beyond what is already carved out in the narrow application of section 47 would be to go beyond the intent of the New Lincoln Court in ruling on Grant versus Davis.
That just sounds like bad law.
I
Why isn't that just bad law?
that section 47, correct.
Yes.
Your Honor, section 47 is not bad law because while it still allows plaintiffs to recover for purely emotional damages, the Hedgepath Court took into consideration that without the type of stringent standard as seen in section 47B in particular, it can open the door for unlimited liability, as any plaintiff could assert that simply because they have a relationship with the defendant, it would be sufficient to bring forth an emotional distress claim. And given that historically courts have been hesitant to award damages for purely emotional distress claims, creating a stringent standard avoids limitless claims or potentially flooding the court with invalid or fictitious claims, particularly given that there is this difficulty of measuring emotional damages.
But whether it's federal or not, isn't this a policy matter that should go back to New England to consider?
No, Your Honor, New Lincoln has formally held that they assert the general no liability rule for purely emotional distress claims and have carved out this narrow application under section 48 and 47. And so this clearly established law is instructive for this court to understand what the intention of the New Lincoln court was in ruling on Grant versus Davis. And if there is to be a new path of recovery as a result of policy considerations, that will be better equipped for the New Lincoln legislature to determine. However, at this time, given that there is clearly established law under the kind of claim that Liam Johnson is bringing forth, the merits of his claim plainly fail.
Also, you mean the clearly established law like Walker?
Yes, Your Honor. Opposing counsel cited to Walker versus Ring in support of the argument that Liam Johnson is a third-party beneficiary of the contractual relationship between Emily Johnson and Dr. Smith. However, this third-party beneficiary theory fails on two grounds. First, given that New Lincoln has established this general no liability rule for purely emotional distress claims, this third-party beneficiary theory is an attempt to converge Section 48, which allows recovery if a plaintiff contemporaneously perceives the bodily injury of a close family member, and Section 47B, which allows for recovery if there is a relationship with the defendant. So even if New Lincoln were to recognize third-party beneficiary relationships, this would not apply in Liam's case because given the facts of Walker versus Ring, there the Indiana Supreme Court held that there was a third-party beneficiary relationship because the doctor was aware that the services being rendered to the mother were not only for the benefit of the mother, but also for the benefit of avoiding physical harm to the resulting child.
But wasn't the service rendered in this case supposed to be for the benefit of the mother and father?
Yes, Your Honor, the services rendered in this case were for the benefit of Emily, but not necessarily for Liam Johnson. And those courts that have
How can it not be for Liam Johnson if the end result is supposed to be a child?
Your Honor, as the court noted in Walker versus Ring, this third-party beneficiary relationship cannot simply be an incidental benefit, but rather needs to be a benefit intended as the physician was rendering these services. And particularly because in Walker versus Ring, the court held that that benefit was conferred to avoid physical harm to the child. That is distinguishable from the fact of our case because Liam Johnson is not asserting that he suffered physical injury as a result of Dr. Smith's negligent actions. And
the loss of weight due to stress and anxiety, physical harm to the human being?
Your Honor, the weight loss and insomnia that Liam Johnson has suffered, as noted on page 5 of the record, are physical manifestations of the general emotional distress that he is alleging.
And a physical injury.
No, Your Honor, given that the courts that have held that there was a physical injury that occurred and as a result there was a viable emotional distress claim, the fact in a number of those cases, the plaintiff first suffered a physical injury and as a result of the physical injury now experiences emotional distress. That is the complete opposite.
Section 48 of the restatement of torts, we allow people to collect damages for negligent infliction of emotional distress.
Under section 48,
Yes.
Your Honor, yes, section 48 does allow for recovery if the plaintiff contemporaneously perceives the close bodily injury of a close family member. Here,
The damages that are allowed in section 48 are for emotional distress.
Yes, Your Honor.
And that's the same kind of anxiety, insomnia, same kind of things that Liam Johnson are declaring here under section 47.
Your Honor, the particular section 48 would not apply in Liam Johnson's case.
They would apply. I'm not asking about damages. Aren't the damages the same?
Not necessarily, Your Honor, because the damages arise out of a different context.
Well, I can't get off this physical injury, okay? The fact that he has different DNA than he would have had he lived in Scotland, that's physical injury.
While that may be considered to be a physical injury, Your Honor, Liam Johnson, I apologize.
So then we can't be in bankruptcy court.
Your Honor, Liam Johnson is not alleging damages for physical injury. He's only alleging damages for general emotional stress. And given that he's not asserting damages for physical injury, that should not be taken into consideration today in this court's ruling of this case. Furthermore, even in those cases where there was a third-party beneficiary relationship, for example, in anonymous physician versus White, the Indiana Appellate Court still also held there that the determination of that beneficiary relationship hinged on the nature of the injury that the child had suffered, which is a particularized birth defect or disorder that the child was born with or had suffered as a result of the physician's negligence. Furthermore, in Walker versus Rain, as opposing counsel noted, in that particular case, the mother was already pregnant with a viable fetus, and as a result of the physician's negligence, that fetus then suffered physical injury. Here, the artificial insemination occurred prior to Liam Johnson becoming a viable fetus, and therefore the facts of that case are distinguishable to the facts of our case. Rather, what a case that would be instructed for this court would be a case such as Rowlett versus Mortimer, where there the Idaho District Court determines that the only patients of an IVF doctor were the mother and the father, not the resulting child.
And Idaho had a special statute, didn't they? I mean, Idaho, you really can't talk about the Rockland case, can you? Because there's a special statute in Idaho.
Yes, Your Honor, while in Idaho, they do subsume other ancillary claims under medical malpractice claims, the court still ruled that irrespective of that statute of limitations, the resulting child still did not have a direct doctor-patient relationship with the IVF doctor.
Don't we have other cases that find that a doctor does have a duty of care to the future child of the current patient?
Yes, Your Honor, there are cases where the courts have held that a doctor owes a duty to a child that is not born at the time. However, in those cases, the physician was typically treating a pregnant mother and their fetus at the time, but that's not the facts of the case presented here in front of this court today. The actions that occurred of Dr. Smith artificially inseminating Emily Johnson happened prior to Emily Johnson having a viable fetus or Liam Johnson being conceived, and therefore this removed nature of these services would be distinguishable from the facts of those cases in which there was a duty of care. Rather, what Liam Johnson is asserting today is a wrongful life claim that New Lincoln would fail to recognize. As noted in the courts by Harbison versus
How do you distinguish the dissent in this case, which found a no wrongful life claim?
Your Honor, and the reason that the dissent noted that Liam Johnson was not asserting a wrongful life claim is because they stated that Liam Johnson does not take issue with his birth itself. However, there, as noted by the courts in Harbison versus Park Davis and in Willis versus Wu, the two core inquiries into whether a claim is not wrongful life is one, whether physicians' failure to adequately inform the parents of a risk caused the birth of a child, and two, but for the physician's negligence, the child would not have been born to experience the emotional distress that they are now asserting. Here, that is the exact character of Liam Johnson's claim. As noted on page 4 of the
Liam Johnson isn't claiming he should have never been born.
Your Honor, the inquiry into a wrongful life claim is not whether or not the child is asserting he never would have been born, but rather whether the child's birth is a but-for cause of the physician's negligence, and that but for the physician's negligence, the child would not have been born to experience the emotional distress they are now asserting. Here, but for Dr. Smith's negligent actions of artificially inseminating Emily Johnson with his own sperm, Liam Johnson would not have been born as he exists today to experience the emotional disorders that he's asserting. And given that there are 38 other jurisdictions that reject wrongful life claims and fail to allow recovery for those damages, Liam Johnson would, New Lincoln would likely, I see that my time has expired.
Okay.
Thank you.
Appreciate your arguments. Thank you, counsel, for your argument for today. Yeah, rebuttal? Yes, sir.
are two points that I'd like to discuss on rebuttal. The first being that my opposing counsel told you that this case was about respecting the intentions of the legislature and respecting established law. However, what opposing counsel did not tell you is that the bankruptcy court did not respect the intentions of Congress when it assumed hypothetical statutory jurisdiction and overstepped the boundaries of its jurisdiction under section 1334B by refusing to analyze the 1334B jurisdiction analysis and instead assume hypothetical statutory jurisdiction outside of the scope of its jurisdiction. To my second point, Your Honors, holding Dr. Smith liable under section 47B of the restatement does not create a slippery slope. It does not create an unlimited scope of liability. Section 47B is a very narrow exception that New Lincoln has adopted and that Liam Johnson's claims fit into because there was a special relationship between Liam Johnson and Dr. Smith that created an especially likely risk of harm to Liam Johnson. Your Honors, it is for these reasons that we ask that Liam Johnson be able to have his say in the proper state forum and you reverse the 15th Circuit Court of Appeal. Thank you.
Thank you very much. Thank you all for your arguments here today. That concludes the arguments in this case. The time for will be in the short recess.
Hi, if our teams and audience want to exit the room so that our judges can escort them, and then we'll ask the teams to come back and simply back.
Well. Yeah.